have one case on the docket this morning, which is Suarez versus U.S. Bank National Association, and we'll go ahead and get started.
Morning, Your Honors. I'm Greg Horowitz. I'm an attorney from Sarasota. I represent Mr. and Mrs. Suarez in this matter that was tried before Judge Gallen in Manatee County. There was a final judgment entered after a trial. We pled as an affirmative defense that the paragraph 22 letter wasn't sent as required by the terms of the mortgage, and I incorporated the terms into the affirmative defense. The sole issue on this appeal is contract interpretation. It's de novo. Did the notice required by paragraph 22 comply, or is it defective? And I think it's undeniably defective. The notice, the mortgage is contract, like any other contract. It's to be interpreted unless it's ambiguous. This court in the Consultations versus Busey Bank case found that this section of paragraph 22 is not ambiguous. It's clear. Shall means shall, and that you have to comply with it. It's really a simple issue.
So what wasn't the issue in Concilian, or was different? The problem in Concilian appears to be that the notice was given only 3 days before the foreclosure was filed instead of 30 days, whereas in this case it's a question of whether the language was adequate.
Yes, Your Honor, good point. And by the way, that's my case, so I'm very familiar with the Busey.
I see that.
With the Busey case.
That's why I figured you know it was
two points.
A different issue.
2 points. If you take a look at the case, it reversed on 2 issues. That they didn't put all the mandatory language in, and because it was untimely. Not just one, both. And in that case, the appellant's attorney, Mark Horowitz, no relation to Greg Horowitz, sent the letter out, and then 3 days later filed a suit. And he left out the entire section D in the notice. That's why the court found it deficient, that the failure to cure the default on or before the date specified in the notice may result in an acceleration of the sum secured by the security instrument, foreclosure by judicial proceeding, and sale of the property. He left that completely out. And if you take a look at the Consulting case, it reversed on both issues, not just the timeliness. And in this mortgage, it says in paragraph 22, and this is the only, I'm going to read it because it's so short, and it's the only issue in this appeal, I believe. The notice shall inform borrower of the right to reinstate after acceleration and the right to assert in the foreclosure proceedings the non-existence of a default or any other defense of borrower to acceleration and foreclosure. The notice in this case says that the borrower has to file its own foreclosure action to assert defenses. So I don't think it's arguable that the notice is not technically deficient.
But you were able to raise defenses in the foreclosure action.
Yes, and we were.
And am I splitting hairs when I look at your third affirmative defense? It failed to serve the acceleration notice as required. So are you saying there was a failure to serve as required, or does it really say it was deficient in its content?
It's ambiguous.
Your defense is ambiguous.
It's ambiguous. We tried it by consent of the parties. The appellee's attorney. I started going into the contents of the letter, which are not subject to any other defense or pleading, specifically, and she did not object to it. It was tried. So she didn't say, your objection, Your Honor, they didn't raise this as an affirmative defense. It's not specific enough. I mean, she either waived it or tried it by consent.
Okay, so
the judge ruled on it.
The record will show that there was an issue tried as to the content of the acceleration.
Specifically.
Okay.
Literally, I had the witness read it, and I read this, your notice. Is that, and then the Judge Gallen ruled on it, and Judge Gallen said that he's got an attorney who gave an opinion to the I don't know how that works. I'd never heard of that before, but I thought the judge made up his own mind. But their attorney has decided in this county that we go by substantial compliance.
Well,
And
isn't that a rule that one can use in any contract? Compliance matter, substantial compliance?
right, and the cases I've cited in my brief specifically say that substantial compliance is in fact compliance. It has to have all of the key terms of the notice in. And the Supreme Court, I cited the cases where the Supreme Court found that a notice did not specify the place of an accident, even though it was a case where it was in Oliver v. City of St. Petersburg. A resident sued after her son was killed.
Well, what about this case out of Broward County where you had apparently the identical problem that you have here, and the court held that substantial compliance was sufficient, absent any prejudice? I realize it's not binding on us, but it's might be persuasive. Why is that analysis not appropriate here?
Because the cases that follow that line of reasoning have to do with repudiation of a contract, or
well, this is a mortgage. It's a mortgage foreclosure. It's the same thing we've got here. The One West Bank versus Andriana.
I haven't seen that. I've seen the circuit.
Well, it was cited in your opponent's brief.
Okay, I missed it. Okay, I apologize, Your Honor. We don't have to. Okay, that's not the correct standard. The case law cited on defective notice by the Supreme Court doesn't talk about it. It has to adversely affect the person who is supposed to receive the correct notice. The Florida Supreme Court has ruled that if you don't technically comply with notice requirements, then you have not substantially complied. There's no requirement to show that you were harmed by it, and that's not what the cases I've cited in my brief state about. None of them talk about you have to show harm.
Are you conceding that there was no prejudice to your clients as a result of this deficiency in the notice?
Well, in actual, no, because I defended them. It's a technical defect.
So again, I mean, it's a yes or no question. Are you conceding that there was no prejudice to your clients as a result of the technical defect in the notice?
In this case, yes, because they hired an attorney, and I was the attorney. However, the notice is not the notice that was bargained for by the parties in this case, and
so what your argument is then is because of a technical deficiency in the notice that caused no prejudice to your clients, we should reverse the final judgment of foreclosure and require the bank to file a new action and start over? Is that what you're requesting?
Well, under the Supreme Court case I've cited, Oliver v. City of St. Petersburg, they don't talk about any type of prejudice, Your Honor, and that has to do with a wrongful death case. These are the cases that deal with notice requirements, not circuit court rulings. This is the Supreme Court, and they found that the technical defect with the notice precluded the mother from maintaining a wrongful death suit. So that's not the standard that the court goes by in defective notices. All of the factual...
What's the nature of the defect in those wrongful death notices?
Didn't give the place of the accident, and it was admitted they all knew where the place was and everything else, but the technical defect precluded the mother from maintaining her wrongful death suit, even though they were on actual notice. They knew where the place of the accident was. That precluded, based upon the city's charter, which required a notice to state the place, as one of the parts, to state the place of the accident. They didn't do it, even though they knew all about it. They weren't prejudiced about it. They did investigations.
But that's a notice required by statute or ordinance?
Ordinance, city charter.
Okay, and what we have here is a contractual provision, correct?
Right.
Don't we always say that substantial compliance is sufficient to satisfy a contract term unless there's a provision to the contrary?
Yes, Your Honor, and this does not substantially comply. This does not give the required notice. It has to give the notice telling the borrowers to go file a court action to allege defenses is not substantial compliance under the cases I've cited in the reply brief, actually. Even when the Supreme Court and the courts have decided substantial compliance, they still say that all of the core terms have to be in there. You can't leave one out. And in this case, this notice is completely erroneous. It deals with states that don't have foreclosures. It deals with states where you have to file your own action in order to defend the case. So objectively, it would put off people from arguably defending the case if you're told you have to bring your own court action.
But here, I mean, you were counsel of record in the trial court, and you filed motions to dismiss, and you filed an answer and raised multiple affirmative defenses. It doesn't seem like there was any way in which you or your clients were misled about the ability to raise defenses based on this notice. Isn't that correct?
It is correct, but that's not the standard. The standard is you have to substantial compliance. You have to have all the terms in the notice.
So basically a magic words rule. It's got to have the exact language.
No.
No?
Not all the, no. Matter of fact, Your Honors, I wanted to point out to the court, I'm not relying on it or citing it. Mr. Stopa, an attorney in town, just had his summary judgment reversed because, and I just want to let the court know, I don't know if the court knows about this opinion, it just came out March 21st.
All right, have you filed a notice of supplemental authority?
No, it's not even final.
All right, well then.
I just wonder if the court would be aware of it.
No. You can't bring up cases that are not in the briefs or unless
I
you
wasn't
file a
going to discuss
notice of
it.
supplemental authority.
Just wanted the court to be aware, so its opinions are obviously coherent, and it dealt with the paragraph. I'm not arguing it. I told counsel, I gave her a copy because I said I'm not arguing. I just want to make the court be aware of it.
If you want to file a notice of supplemental
No,
authority later, you
not
may,
final.
but I'm not going to allow you to
Yes,
argue
sir.
it now. Move on to something else.
Sir, I wasn't trying to. I apologize. Yeah, well, I don't have any further argument.
All right. I'll let you save 5 minutes for rebuttal then.
Thank you.
Good morning. May it please the court. My name is Susan Capote. I'm here on behalf of the Appellee U.S. Bank, and I am from the law office of Wargo French. Your Honors, the appellants here are suggesting that U.S. Bank is asking the court to interpret this contract, and that it is asking the court to read terms into that mortgage contract that are not there. That is incorrect. U.S. Bank concedes that paragraph 22 of the mortgage contract creates a condition precedent to filing suit. The issue here, there are two issues here, according to U.S. Bank. Number one is that the affirmative defense that was raised in the underlying action by the appellants was insufficient to put U.S. Bank on notice of what they were going to plead at trial. As it was read into the record, I believe, the affirmative defense said defendants affirmatively allege that plaintiff has failed to meet a condition precedent created by the mortgage because it failed to serve the notice of pre-acceleration before filing this action as required by the covenant of the mortgage. See paragraph 22 of the mortgage, which is incorporated by reference. It incorporates it by reference, but the affirmative defense itself does not say that the notice was insufficient. It merely says that it wasn't served.
But
Thus,
Mr. Horowitz tells us that the issue as to the content was argued below and
The issue-
addressed below, so if it was tried by consent, we're beyond this now.
Your Honor, it is U.S. Bank's position that it was not tried by consent. To start, the letter was introduced into evidence as it would have to be in order for U.S. Bank to be able to foreclose. It brought it, in fact, it had to refute the affirmative defense that was pled, that it was never served. It established this through the testimony of its witness and through the introduction of the letter itself. Opposing counsel questioned the witness on legal issues that the witness himself was unable to testify to because he was asking whether the notice itself complied with the contract. That's a legal conclusion. That's not a factual question. And without any further questioning, and opposing counsel is correct that prior counsel did not object to the line of questioning, the court did state that the courts are concluding that this language substantially complies. And I will argue in a minute that we agree with that. However, that is not what trial by consent is. Unfortunately, I cannot cite to cases, Your Honors. We did seek to file a reply to that issue. It was denied. Thus, we did want to address that issue, and if Your Honor allows us to supplement the record with case law, we will. But and if it is improper to state that the correct standard on a trial by consent is whether there is any prejudice to the party that is opposing the trial by consent, and if they were, whether the opposing party would have had the opportunity to introduce, would have had a fair opportunity to defend or to introduce additional evidence to be able to support its position. And there are things that, had we been put on proper notice of what the opposing side was going to argue, that there was some sort of insufficiency with the notice, we may have been able to submit testimony regarding industry standard. We could have possibly hired an expert to discuss what those terms mean. We don't know, but we weren't put on notice, so we don't know what we would have done had we known what that notice, what that affirmative defense was meant to say. For all we know, we might have decided to voluntarily dismiss the case back at the beginning if we considered that the notice itself was deficient. However, this was allowed to go on from 2010 until the date of trial, and then we were ambushed with this, but this is what we really meant, and it was incorporated by reference. So it is U.S. Bank's position that this was not tried by consent, and as admitted by the appellants, the affirmative defense was ambiguous.
But I can only assume that you took some discovery as to the bases of the defenses.
I'm sorry?
I am assuming that you took discovery as to the bases for the affirmative defenses.
There wasn't a great deal of discovery, Your Honor, below, and I don't know the reason for that.
Okay.
Our second position, Your Honor, is that even if this court were to conclude that the affirmative defense was sufficient, even if it was to conclude that the issue was tried by consent, nonetheless, the notice did comply and substantially comply with the requirements of the condition precedent. Now, the cases that, according to appellants, this issue has been, and I want to use the right word, decisively ruled by the courts in this state as far as compliance. That's somewhat of a misrepresentation. There are 14 cases cited for this position on page 4 of appellant's reply brief. Every single one of those cases, to start, is a motion for summary judgment case that was ruled on. 13 of those cases, none of them discuss anything having to do, actually none of them, all 14 cases none of them discuss substantial compliance. All of them deal with the fact that on summary judgment, a plaintiff has the burden of refuting affirmative defenses that are raised in the pleadings, because it's a very high standard, and because they failed to address the affirmative defenses, the appellate courts reversed. That's all 14 of those cases. Only one of them addressed the prior issues dealing with the sufficiency of the affirmative defense. The notice here, now the provision, paragraph 22 of the mortgage contract has many requirements. Opposing counsel is focusing on one, and if the court allows me to go into that, paragraph 22 has 6 requirements that we've broken down, and the provision itself is in the record, page 19 of the record, and it's not bolded, and that's the acceleration remedies paragraph, and it has 6 requirements. One, that the notice has to specify the default, that it has to specify the actions required to cure the default. It has to give the borrower at least 30 days to cure the default from the date the notice is given to the borrower. It has to inform the borrower that failure to cure the default within the 30 days may result in 3 things: acceleration, a foreclosure proceeding, a foreclosure by judicial proceeding, and sale of the property. 5, it must inform the borrower of the right to reinstate the acceleration, and it has to inform the borrower of the right to assert in a foreclosure proceeding 2 things: the non-existence of a default and any other defense to acceleration and foreclosure. It is undisputed that the notice that was sent out to the borrowers here strictly complied with the first 5 of those requirements. The appellants do not dispute that. The 6th requirement, they do not dispute that it informed the borrowers that they were able to raise defenses as to the non-existence of a default and to raise any other defense as to the foreclosure as acceleration. The only issue here is one small phrase, because the letter said, instead of saying that they could assert in the foreclosure proceeding the non-existence of the default or other defenses, it said instead that they had the right to bring a court action. That's the only difference. Everything else was complied with. It is U.S. Bank's position, and it is, quite frankly, most of the courts that have looked at these issues, position that that is substantial compliance. There is no case on point in Florida having to deal with a default letter and substantial compliance. But I would ask the court to follow the reasoning in a case actually cited in opposing counsel's brief, which is School Board of Palm Beach County v. Fasano. It's 417 Southern 2nd, 1063, and it's from the 4th DCA. In that case involved, it was a statute that had a condition precedent that a claimant that was working with the school board and was going to be working with subcontractors had to submit a notice to the subcontractors and there was specific language that was quoted, that it intends to look to the bond for protection. The particular letter that was sent out to the subcontractors and the surety in this matter had all the other requisite information regarding the materials they were using and the labor that they were going to use. However, it didn't use the precise intends to look to the bond for protection. The court there concluded that this was substantial compliance with the notice requirement, therefore there was substantial compliance with the condition precedents, because in essence, all of the factual information required by the statute was provided to the contractor. It is the same issue here. All of the information that the borrower needed to know was provided, including that there would be a foreclosure proceeding, that there may be a foreclosure proceeding filed against them if they fail to cure the default. And again, there is no prejudice here. The standard is whether there is prejudice, at least according to the 4th TCA's ruling here, that if there was any prejudice that if there was no prejudice, then therefore what was the harm? There was actual notice. Here, every right, every bit of information that the borrowers needed to know was in there. What was the default? What do we need to cure it? By when do I need to do it? That they had the right to reinstate the loan. What the consequences would be if they failed to cure, and that they would be able to raise defenses, as these borrowers did during the last 4 years, they raised defenses. In fact, I believe they raised 9 affirmative defenses in their answer. They were on notice of this. They've never alleged, nor did they ever file a separate court action and waste attorney's fees or court costs filing this separate action because they followed this erroneous instruction. They did nothing. They hired an attorney.
Well, really, I mean, that would only be appropriate in a jurisdiction that had non-judicial foreclosure. Is that correct?
Absolutely, Your Honor. And this is probably where this came from. That this would have been a letter that would have been proper, that would have been, the terminology probably came from those sorts of jurisdictions. But nonetheless, this letter gave every bit of information that was necessary for the borrowers that is provided for in provision 22 of the mortgage contract. While this state has not looked at this issue, other states, Connecticut in particular, the state of Louisiana, have looked at the issues of this, the substantial compliance when it comes to the default letters in a mortgage, and in both of those jurisdictions, particularly it's MERS v. Goduto, which is 110 Connecticut, APP 367. Literal enforcement of the relevant notice provision would serve no purpose because the defendant had actual notice of his right to cure his default prior to acceleration. It's a similar holding here. So again, Your Honors, and going back, the cases cited for substantial compliance and spoken about, Olivier, the District Court of Trustees v. Allen, Midtown Enterprises, each of those notices failed to provide a material term necessary for the notices. Very similarly to cases here like Concilian, where it said you have 30 days, but then they only gave them 3. Or if it had erroneous information, if it gave them erroneous information about what they needed to do to cure the default or something. They failed to, in Olivier, they failed to say where the accident occurred, which was a prerequisite. In Midtown Enterprises, the notice itself, the statute provided a form letter that had requisites that the individuals and the claimants had to complete in order to state a claim. They missed like 4 of those requirements. In District Court of Trustees v. Allen, there was a requirement that when property was going to be taken by eminent domain, that there would be proof of negotiations with the owners. The notice there said, we're going to take your property if you don't sell. There was no offer, there was no evidence of negotiation. That's very different than the case here, where actual notice was given and all of the material terms were included in the provision. Thus, Your Honor, it is U.S. Bank's position that because the affirmative defense was insufficiently pled and did not properly put U.S. Bank on notice, and in addition, because the notice itself substantially complied with the condition precedent to filing suit, we respectfully request that the court affirm the final judgment that was issued at trial. Thank you.
Right. Thank you, ma'am. Mr. Horowitz, I'll let you have 5 minutes for rebuttal, sir.
Thank you. Your Honor, it's not up to the court to fashion a new remedy between these parties. The contract, the mortgage is clear and unambiguous. Concilian states that this paragraph has to be complied with, and the party's contract says the lender shall inform the borrower of the right to assert in the foreclosure proceedings the non-existence of a default. They didn't do that. It's not in dispute. They did not comply with the requisite notice. As a matter of law, the notice does not comply and is defective. And if you take a look at second paragraph of paragraph 20, it states that you can't bring a foreclosure action until you complied with the notice. It says you can't commence an action. and it says that, refers to paragraph 22, that would be sufficient under paragraph 20. It's not up to the court to fashion a rule to say that we have to show that we've been injured in some way. It's a notice requirement. And there's all of the cases cited in the brief state that substantial compliance, you still have to give all of the required notice, parts of the notice, to be in substantial compliance. I understand, Your Honors, it's a technical defect, but this is the law. And the only cases cited about substantial compliance say that all of the terms have to be in there with the notice. So as much as the court would like to rewrite the contract and say they have to show prejudice, they don't. It says they have to give this notice, and if they don't give it, they can't commence an action. So thank you, Your Honor.
All right, thank you both. That concludes our short docket this morning, and we'll be adjourned.
Thank you.